Good morning and welcome to the Aird and Burles LLP webinar series. Today's topic is Blitz-Proof Your Workplace, How to Survive and Thrive During an Inspection. Today I am joined by my colleagues Cynthia, Sefton, and David Reiter, who are going to take us through the workplace inspection Blitz process and give you a sense overall, not just of what the government is thinking, but also how you can practically manage through with your business in both an efficient and practical way. Workplaces across Ontario are put on notice by the Ministry of Government on a yearly basis, but they were told specifically that the next round of blitzes is going to take place during the year April 1 of 2018 to March 31st of 2019. So we've kicked off on that. Sorry for all the football analogies, kickoff, blitz, it's all the same thing. The 2018-19 schedule for blitzes is going to deal with provincial blitzes, provincial initiatives, and regional initiatives. So what I would like to do is pass this on now to my colleagues, and let's get into it. And if you have any questions during the process, please send them in, and we'll have time at the end. We're going to make time, and we'll make sure that we get answers for you. Thanks very much. Cynthia?
Thanks, Lorenzo. So the first question is, how is an inspection triggered? Why is the inspector at your workplace in the first place? And there are a number of ways in which the inspector can show up and under different initiatives. And the first, as Lorenzo already mentioned, is part of a pre-announced blitz, whether provincially or regionally. And the ministry tells you the various industries they're going to cover and the various highlight topics they're going to look at for compliance. You can go on their website and see it, and it's free to look that up. What they don't tell you, however, of course, is whether they're coming to your specific business. But as a matter of planning, you should assume that you will be one of the workplaces inspected if you fit the criteria. So that's the first way. The second way it can be triggered on a construction project, and we don't have enough time in this hour to take us through what that actually means, construction project, but as I'm sure you all know, where there's going to be a certain duration of work, a certain value of work, monetary terms, and number of workers, the Ministry is provided with notice that the construction project is taking place and can and will drop by at any time to look for compliance. And the last way is the basket other. So, for example, complaints, if they've dealt with you before and there should be some follow-up in their mind. There's a wide variety of ways in which an inspection can be triggered under other. David?
Sure, and just still on that point very briefly, we're going to be talking later on about a case when we get to the working at heights section, because that's one of the blitzes that's coming up. But that case is Alice Dawn from 2006, and in that case it was just a Ministry of Labor inspector driving by and saw the construction site, parked across the street and watched, and then started conducting an inspection. So they can be triggered in any number of ways, and the only indication of what we have of where people are going to be going, or inspectors are going to be attending, comes from the schedule that Cynthia was referring to that's posted on the website. But turning to the second question that we've asked, what is a blitz? And this is part of the Safe at Work Ontario initiative, where the ministry has teamed up with the WSIB and with other prevention partners, such as the Industrial Health and Safety Association and the like, and they identify where there have been recurrent accidents, where there are sectors that are at high risk, such as construction, obviously, and what portions of construction, and they attend at these sites. And this is the schedule, again, that Cynthia was talking about. There's a new approach this year, which is set out in the ministry's website, which talks about two phases to the inspections. We now have phase one of the inspections, which is a training and information initiative. And what the ministry is doing is it's partnering with organizations such as the Industrial Health and Safety Association and the like, and they are going through the first phase of the inspections or the Blitz, I should say, providing information and education. And then the second phase follows a month later, where they're going to be attending at workplaces and actually conducting the inspections from an enforcement perspective. There are 6 places that the ministry's schedule sets out where we're going to have these 2-phase inspections or blitzes happening, and that's in construction and mining, healthcare initiatives. There's a focus on municipalities and ergonomics, and temporary and foreign workers in hotels. And that's going to be happening throughout the course of 2018 and 2019, and the details of when each attendance is going to be happening is set out in the ministry's website.
And just interesting thing when you look at the website, they do talk about the industrial blitz focus being on new and young workers' health and safety. That's always been a really big deal, particularly for the Workplace Safety and Insurance Board, that they want to make sure that that young workers are not at risk, because oftentimes they're the vulnerable workers when they come into an industrial establishment. And I thought, very interesting, maybe you can comment on this, the health and safety in warehouses and big box retail, which is also another, it seems to me to be kind of another initiative as well.
Well, there have been a number of cases of collapse of shelving and driving those big pieces of machinery to load and stack boxes over the last several years. So I think that probably raises the focus of the big box store. The young worker blitz has been included in prior blitzes as well, as you know, and if anyone has a kid or knows a kid that's going out to get a summer job, that can be a situation of great exposure to danger, because they get a limited amount of training given the time involved. And so Lorenzo's quite right. That's always been a very serious issue for the ministry, and it should be. So just following along on what is a blitz, and why do we have them? The first object of the exercise is to raise awareness within the workplace and amongst workers of known workplace hazards, which happen still too often: guarding, shelving falls, traffic accidents with big equipment, slipping, those kind of things. These are not rocket science hazards in the sense that they've been occurring too frequently over the last years, but raise awareness, make people perhaps even look at their policies and procedures just by the announcement of the blitz, and that in and of itself is a good goal. It's also intended to ensure compliance. And as David mentioned, in the first place, there are some businesses who do need assistance with training and with a knowledge of the requirements, and the ministry can provide that in its phase 1. Of course, there are sophisticated businesses who will not be afforded that same luxury, and they may skip into a phase 2. The other thing that's important to remember is that, as David said, with the Elliston drive-by and the inspector being curious as to what was going on, just because they're there to look at young workers, if they see something that is not in compliance, that can be addressed as well, and likely will be. So don't think just because, I'm covered off on what this particular blitz is to be about, that you can ignore the other, what I'll call obvious aspects of safety. Your whole shop, your whole site, your whole office should be tickety-boo and in compliance. And then finally, the blitz results by sector and issue are published on the Ministry of Labor website. You should go and take a look at the 2017 reports, because it's very interesting that in the last X number of years, the same issues continue to be a recurring theme: falls, guarding, tying off, scaffolding. the same issues continue to be a recurring theme, and that just bodes for, in our view, more enforcement and less slack being cut on those issues.
All right, so one of the questions we've been asked many times is what can an inspector do on an inspection? And so we're starting off with this slide and this point that an inspection is not an investigation. The Occupational Health and Safety Act grants an inspector specific powers, and they're very far-ranging on an inspection. And they include, it's all set out in Section 54 of the Act, but they include they can attend at a workplace at any time without a warrant or notice, they can inspect any machinery, they can speak to people about operations, they can ask for the production of records, they can ask that tests be conducted on equipment, they can require that certain things be done, such as reports be produced, or that reports be commissioned. They have a wide-ranging number of powers. But what happens is when the line is crossed during an inspection and an inspector identifies reasonable and probable grounds to believe that an offense has been committed or a contravention has happened, then those inspection powers cease and you go into a different section of the Act under Section 56, which requires you to get judicial authorization to start compelling the production of information. So what does that mean? It means if they find something wrong and they're looking and thinking about charges, they can't anymore exercise these powers.
So practically, what does that mean to an employer who has an inspector there? When will they know the signs as to when that kicks in?
So an inspector is supposed to warn the employer and provide a caution at that time if that line is crossed. If an employer starts getting uncomfortable with the series of questions or the nature of the questions that are being asked, they can ask, are you looking at charges? The inspector doesn't have to answer, and the inspector very rightfully may answer that I don't know what I'm dealing with. There are a lot of different issues I'm looking at. I'm still going on an inspection. So I think the advice that Cynthia and I usually give is that you document what's happening and you be respectful to the inspector, and if you have a real concern, contact your counsel.
And I think it's important to remember that, you know, these situations, like Lorenzo said, oh, am I now in what's called a Jarvis and Ling line? Because those are the cases that set out the line between inspection and investigation. And to be fair to the inspector and to the employer, yeah, it's not always clear. Mm-hmm. But one thing that is clear is that refusal to cooperate with an inspector in the course of performing his or her inspection is an offense under the Occupational Health and Safety Act. So I think what is also important is to make sure that everything is ready and that people are aware that they may have to speak to the inspector and they know that they should be accurate and truthful. And this requires the appointment of a point person. And that point person should be someone who is comfortable dealing with the inspector and will either know the answer to why is this machine guarded or not guarded, or will know where to find the answer. And it's always best, if possible, to have one contact person, because the accurate information is more likely to come out if it's funneled through one person. However, if an inspector sees a machine operator, a bulldozer operator, a crane operator, and wants to go and talk to him or her, they're free to do so. So, especially on the Blitz topics, we think it's worthwhile having what I'll call a pre-session. In other words, one morning, one afternoon, for a half hour, cover what your people are supposed to do when the inspector shows up, and explain to them that it's not a situation where you're being pulled over and asked to do a breathalyzer. This is part of the inspector's routine duties, and he or she has not just the right but the obligation to do this. So, Lorenzo, it's often not very clear at all where the line is. But, sorry, I was just going to add that if it's an individual, versus the employer, the rights may be a little different.
I see.
Because the individual who is under investigation, in quotations, may have certain rights to silence that the company does not have. But I think from a practical perspective, if they're sufficient to put individuals on the spot as to potential charges, there will be a feeling in the room that that is going to happen. And if in doubt, ask the inspector. David said they don't have to reply.
Yeah.
But sometimes they will, and sometimes they won't know yet.
So the bottom line is, and we don't know exactly how much time you're going to have by the time they let you know that they're going to be in otherwise, but you have to have a process in place already that you're ready to go. If you're scrambling when they contact you, they're going to get, or you're going to give them the wrong type of information, or something's going to go wrong. So really it's the preparation that's the important part here.
And also you're going to give them the impression that you don't know what you're doing.
Exactly.
So get credit for what you do know and what you've established.
Okay.
Okay. Internal responsibility system. You all know this. The language has been around for a good few years. But we just thought it would be important to remind you about who has what responsibility. And it's also important to remind you that since David and I, certainly I, because I'm a lot older than he is, but since we've been doing this work, the tolerance for risk and injury has shrunk, as it should, especially when you see the same issues over and over again. So there's a few points. Just because someone that you hire, someone that you buy from, someone that you're on the site with messes up doesn't relieve you from the obligation to do what you have to do. There can be more than one party who breaks the rules. And you have responsibility not just for your own direct employees, but your contractors. In this contract out world, there's nothing wrong with that. But it removes you from the close relationship that you might have with your own direct employees. But you're responsible, so satisfy yourself that they're doing the right thing at apartment buildings, at job sites, anytime you hire a contractor. Zero tolerance for workarounds. And I'm sure David, I hope he'll agree, because we both seen it in cases we've done together and separately. If there's a workaround or a shortcut, it's very unlikely that it's the first time it ever happened. And turning a blind eye to those kind of things will get you in trouble. You have to go out and look for them, not wait till it results in an injury. You have responsibility for not just your best worker, but perhaps your not so good worker or your disobedient worker. And finally, note, there need not be an accident or an injury for there to be a charge. Because if the object of the exercise is prevention, why wait for the bad thing to happen?
And just on the issue of responsibility for the less than stellar or disobedient worker, from an employment perspective, you actually have to show, whether unionized environment or not, that you're taking steps to train that worker, but also to discipline them if they're working negligently. Right, and that's a real issue, and David might be able to speak to that a little bit as well.
And just to build on that, we're seeing that, I have that in a case right now, we're seeing that every time almost in cases where the company does have policies and practices and procedures that have been reduced to writing saying you have to take step A, step B, because you don't create negligent or insufficient policies. The problem is happening when you're out on the floor or you're out in the field. And we're seeing any number of the cases where the policies are actually not being followed, and the courts are saying time and again, you have to not only protect the diligent worker, but the negligent worker, because people don't intend to injure themselves. Yeah. People don't intend for this to happen, so you have to watch for it. And if you have a history of this happening, and you haven't dealt with it by discipline, you've got a problem.
I've got a case right now where the employee has, over the last 2 years, injured himself to the point that there's been a WSIB claim 11 times in 2 years, and not minor ones. They might be a twisted ankle, but there are cuts, there are stitches, right? There was a risk. So these are kind of ongoing issues that we had to deal with from a disciplinary perspective to say you're working in a way which is unsafe to both yourself and perhaps to other workers. And that's magnified if they're operating a piece of equipment, a tow motor, or if they're doing something which actually might bring greater exposure to other employees and themselves. So it's a very good point to remember.
Right. I guess it crosses the line between the employee and his or her action and it becoming the employer endorsing that culture.
And if you have a union, you're going to get a grievance if you discipline somebody for working negligently. You got to expect that. So that's why it's even more important to rely on the collective agreement provisions that talk about health and safety, about the obligations at law to ensure that there's a safe workplace. That will push the union back a little bit.
So the next question we're looking at is, what is the inspector looking for? And I think it's helpful to explain just very briefly what you can expect when an inspector attends, first of all. And the first thing is they're going to attend at the premises and they're going to ask to meet with the most senior member of management and a workplace health and safety contact. So as Cynthia was saying before, you're going to have your contact, your point person ready, and you should also make sure that whoever is in management that may be responding is also either the contact person or trained properly for this attendance. The first thing that the inspector will probably be looking for, they have a checklist. And they're going to be looking for the written policies. Under the Act, employers are required to have written policies. They're going to be looking for the violence and harassment policies that are required under Section 32.01 of the Act. They're going to be looking to see whether the Act is posted, which is another requirement that employers have, and whether you've got the health and safety posters up as required. Once they've gone through that checklist, and that's easy enough for anyone to prepare for, then they're going to start doing a walkabout, and they'll go along with the Occupational Health and Safety representative or the point person, and they can take a half day to more, depending on the size of your facility or of your workplace. And they're going to be going around looking at the machinery, looking at the processes, and trying to identify if there are any deficiencies or contraventions. And we'll talk about it a little bit later on when we look at the 4 types of blitzes that are upcoming in the industry sectors. But there's ways to prepare for this by looking at hazard alerts that the ministry puts out for your specific industry or for the topic that they're looking at, and you'll be able to identify steps that you should be taking to prepare. But that's what the ministry inspector is looking for. They're going to be asking for you to prove all of these things. So as Cynthia said again, you're going to want to have all of your records ready and accessible. And I appreciate that sometimes it's hard to have everything at your fingertips, but in this digital age, it should be something that you can pull up relatively quickly, and if you can't, you tell the inspector, we can get it for you, we know where it is, it just will take us a half an hour or a half a day, but we will get it to you. And make sure you keep records of what you're being asked to produce, because you don't want to overpromise and underdeliver. Not in this situation.
And just to follow on what David says, do not, under any circumstances, pull out a binder that has dust on it, because that just shows that nobody ever looks at it. So, it is really a bad and inexcusable mistake to not comply with the posters and the posting of the Act in the languages of the workplace and so forth, because those are so easy.
Yeah, that's the easy stuff.
That's
if you're not
easy.
doing that, what else are you missing?
Exactly. And the culture thing gets overused as a term, but it really is important, because the inspector is looking for a serious approach to safety, not just a checklist that people check off because they don't want to get prosecuted. So the next slide is, what powers does an inspector have? And we've already talked about it a little bit, and where is the line between inspection and enforcement? And David's mentioned the 2 sections of the legislation. By the time the inspector has gone out to get a search warrant, you're clearly into an investigation. And David and I actually, I won a case with David years ago about when you can get a search warrant and when you can't, because we were in the middle of a trial, and then the inspector ran off to get the search warrant. But there's a very big gray area between a pure inspection and this is clearly an investigation to lead to charges. And it's that gray area that you're going to have to use your common sense for. And as David said, have someone take notes. And the powers are clear. And again, strictly enforced, and do not refuse to cooperate. If you don't have the information at your fingertips, as David said, you need a half hour to go and find it on the computer, that's fine, but just say, you know, we are of course cooperating with you, but can we get you a copy of that at the end of the day, or can we deliver that to you tomorrow? And if the inspector is reasonable, which most of them are, they're just people doing a job, they'll say, sure. But for goodness sake, do not fail to provide the information as promised. Because just like you, when you're dealing with a situation where you have to have a little trust in somebody, if they feel that they can't trust you because you don't deliver, as a practical matter, you're going to be in trouble. If someone is doing an investigation and they ask an individual to give a statement, at that point, the individual is free to ask, am I under personal investigation? Or his or her supervisor can ask that because the individual may be a little anxious. And if they're under pure investigation, in other words, the inspector's head has crossed the line, there will be generally a caution. But that situation is at the same end of the inspection of the attendance as the search warrant. So if people are being interviewed, they are being interviewed generally as part of the inspection.
Just talking about the powers that an inspector has in addition, not only can they ask the questions and ask for the production of materials, they can also issue orders. And this happens a lot, and we see that if you go to the Blitz results, a lot of orders, thousands of orders are being issued in response to each specific Blitz. And they can order you to bring something into compliance, they can order you to repair or rectify something forthwith, which means by the end of the inspection, they can stop work and shut you down. And you have avenues, when we'll talk about this in a few slides, about how you can deal and respond with that if you think that an order is inappropriate. But it is an offense not to comply with an order. It's that simple. You either have to appeal it and get a stay, which we'll talk about, and if you don't, then, and you don't comply, you will likely be charged. This is a big deal for the ministry. I'm dealing with a case right now. So one thing that I strongly recommend is if you get an order and it has a compliance date a week or two down the road, and you don't understand something, if you are not 100% clear on what that order requires you to do, ask. Sit down with the inspector, make sure you're clear, because you do not want to face a charge for something as silly as not listening to their direction.
So would you recommend that be, for example, in writing, in an email or something to the inspector so you have proof of what you've asked for clarification?
Sometimes that's not going to be something that you can do because it's going to be something that happens immediately. If you have that opportunity time-wise to send off an email to clarify saying this is what I understand it to be, I think that's great advice. If not, right after you've asked the question and after the inspector leaves, document it. Write a note at the time, because that will be something you can turn to later on as proof of what your understanding was in the inquiries you made. But yeah, you need to document this somehow, and you need to ask.
And remember, too, that these inspectors are oftentimes overtaxed in terms of what they're doing. They don't have the resource. They're working hard. They're probably working more hours than they probably think they're getting paid for. Make their job easier if you can. Assist. Don't be, if you're an obstacle, it's going to make their life more difficult. It's going to put them in the wrong mood. I'm not saying give them everything, but just make sure that you're not being an obstacle to this.
Yeah, and on that point, I was looking at some of the cases yesterday and dealing with orders and appealing orders, and the courts are going to give the inspector so much latitude on this because this is all about protecting worker safety, so it's going to be read as broadly as possible based on what the inspector knew.
And very often, on cases that we've all dealt with, the order is simply in the terms of the legislation. In other words, comply with Section 104 of the construction project construction regulation that says X. So if you don't know why you're not complying and you think you are complying, do have a discussion with the inspector if they're willing to do so or prepared to do so, because the last thing, as David said, you want to do is fail to comply. And you have to notify the ministry when you have complied. And that means that you can't just say, yeah, we'll do it and put it over on a shelf somewhere. There has to be a real attempt to understand where you're not complying and how you should get there. And if you don't understand and the inspector is not of assistance, go to your industry association. Go to your competitors. Go to Aird & Burles, or your own lawyer. Go to someone who's dealt with these things before. Don't sit there scratching your head saying, oh my goodness, I thought we did have our machines properly guarded. So the next slide is process steps to get ready, and we've talked about this a little bit already, but do have the designated point person. That way you can say to the inspector that, hi, I'm General Manager A. Thanks for coming, and I will get point person B, and she will accompany us on the visit, and that person should either know the answer to getting records and information or know who to go to. Also, the Joint Health and Safety Representative, I think it's a good idea to include them because you want to know if there is an issue. And just like having the point person, the Joint Health and Safety Representative should be spoken to before. What are your concerns? How haven't we addressed them, and how have we? Don't, by the way, have minutes of joint health and safety meetings that raise the same problem over and over again, like construction site meetings. You know, nice clear day, inspector present, all good. What does that mean? Make sure that there are specifics, and if they're raised, address them. That doesn't mean you have to do everything requested, but it means you have to turn your mind to the question and make a decision one way or the other that's rational and that you can explain and justify to the inspection. The required documentation, as David said, in the digital age, there's no excuse for not having information available, if not right at that second, then within a couple hours, or at the latest the next day. And also, if you're going to have training, which everyone does, make sure there is a genuine attendance record, as opposed to whole group came. What does that mean? Just put yourself in the shoes of the inspector. What would you, as a logical, mature person, ask in his or her shoes? And as Lorenzo mentioned, attitude can be very important. Professional, courteous, by no means should you be combative. Sometimes, and lawyers often do the same thing, we get our back up a little when someone is questioning, well, why did you do that? That may well be, but for goodness sake, do not show it. And introduce to management, supervisors, and workers, and make sure you follow up. The devil's in the details.
One thing I'll add to that in terms of the documentation is you know your industry, you know what you're dealing with. So, for example, we know that the big box retail stores are going to be subject to a blitz. Lorenzo was talking about that a little earlier. And we know that they use forklifts and lifting devices. Well, there's a requirement under the industrial regulation that they have annual inspections. Make sure that documentation is ready and available. The same thing with harassment and violence policies. You have to have annual updates to that. Make sure it's there well in advance of the attendance, because these are documents that you're going to be likely asked to see just as part of checklists.
And one thing that I might mention here is that where you've got a unionized workforce and you've got union representation on a joint health and safety committee, sometimes you will find, and not all the time, but you will find that that representative on behalf of the union can be quite combative with management, not necessarily with the inspector, but with management, and that can reflect itself sometimes with the comments they make, what is detailed in the minutes. You need to be very vigilant that you're addressing those issues from a straight-up perspective so that not everything that they may put down or say in that meeting is taken as 100% gospel. I think that's very important because that is where if there's an axe to grind, you will often see a union representative grind it right there.
Okay, so turning to the next slide, we've set out, Cynthia and I have talked about this time and again, steps to get ready just in general for making sure that you have your diligence addressed. And the first thing is obviously having up-to-date policies, practices, and procedures. And these should be informed by the issues that have arisen at work, by the procedures that you undertake at work, and also by the hazard alerts that the ministry puts out. There are going to be incidents time and again where things are repeating, as we've talked about with fall arrest, and safety training, things of that nature. And you need to have those experiences inform your policies. It can't just be a policy that has no relation to the actual on-the-floor workplace. The procedures, it's the same thing, but they have to be clearly written. It doesn't help if it's written in a language that only an engineer can understand, and you've got somebody who doesn't have that degree, and they're trying to operate machinery. They need to have clear, simple procedures. And it may seem silly, but sometimes the procedures have to be first do step A, then do step B. Things that you would think are obvious. Do not put your hand in the machine. You have to have that in your procedures as warnings, because we're seeing time and again that charges come about on inspection, after inspections or investigations, where they didn't have those warnings, and then you get a charge under the Act that says fail to inform or provide information, instruction, or supervision. Training, as Cynthia said, critical, and the sign-up lists that when you actually have people attend the training, make sure they actually sign in on an attendance, as Cynthia said. You'll be able to turn to that later on. And it doesn't help just having a sheet that says, it's titled Trained on Procedure X. Attach the training to the back of that sheet. So, for example, if you used a PowerPoint deck of slides and it went through certain points, you want to attach that to the attendance list so you'll be able to show exactly what was done. And Cynthia just passed me a note that says dates. Absolutely. You need to make sure that it's clear when this was done so that you can show you're being diligent on a repeated basis.
And if you're doing anything which the records are digitally or on your intranet, there are ways to ensure that they click that they're in attendance so that they recognize that they're there, or at the very least, make sure that your attendance sheet, which is loaded on digitally, shows exactly who was there and who signs off that they were there.
Absolutely, and it's not funny, it's surprising, but I see case after case where you'll have a worker who's interviewed, who's asked the specific question, did you receive any training? And their answer is no. And then thankfully, my client will be able to pull out all of the documentation that we're talking about and saying, what are you talking about? I'll go back and re-interview the worker, and we're going to say, oh, well, I didn't realize that's what he was talking about or she was talking about, and we're able to clear up the problem. You don't want to have that problem from the first place. So if you have the records, you can head that off at the pass on the inspection.
You know, how you provide the training is really up to you. because you know your business, you should know your workers, and you should know what they need to know to do their job safely. So we're not here to tell you do it this way or don't do it that way. And I know online training is all the rage these days, but I'm a little old-fashioned, and I think it's important to spend some time in person with workers performing what I'll call risky jobs, so that you get some amount of feedback. Are their eyes simply glazing over, or is what you're saying to them being received? Just to follow on, supervision. What does that even mean? Does the supervisor have to be right beside the worker the whole time they're doing their job? Well, if you think that's necessary to ensure that the job's performed safely, yes. At the very least, you should be able to demonstrate that there was some sort of what I used to call a ride-along. In other words, when the worker starts the task for the first time, and especially with new and young workers, that they're being watched, hands-on, performed, and corrected during the course of that supervision. And that's more difficult to do, obviously, with contractors, but at least you should be satisfied that they have their own supervisor, and he or she has done the same thing that you would do with your own workers. Monitoring. How are we doing? Is it working? Are there mistakes? Corrective measures. Enforce them. Lorenzo and David are so right on that. And then start over. And if you do all these things, you'll be absolutely satisfied that you won't be prosecuted, or you may be, but it'll be less likely, and you might even have a defense.
Turning to the next slide, so we talked about this very briefly, about your rights as an employer. And obviously you can't interfere with the inspector. If he or she is exercising a power that they have under the inspection section in the Act, you can't interfere with that. That will be an offense. You also have an obligation to assist in every respect with that inspection. And if you don't, that also can be an offense. I've seen cases where somebody was asked a question and they were less than forthright and they got charged on an inspection. So you have to deal with that. So how does it work if you don't agree with an order that gets issued on an inspection? Well, you can appeal it, and you can ask that it be stayed pending the appeal so that it doesn't have effect. The stay will only be issued if it's not an issue that addresses immediate worker safety. So, for example, if they've issued an order that you have to put guarding in place and you can't use the machine until the guarding is in place, you're not going to be able to overturn that or get it stayed unless you can show that it's not a safety hazard. So you have to always have that in mind, because that's what the Ontario Labour Relations Board is looking at. We've put in a case here that just gives an example of how you can appeal. And it, very briefly, all this case dealt with was a fatality at a swimming pool at a resort, and it did not involve a worker, and the inspector came out and issued a requirement that a notice be provided. That got appealed all the way up to the Court of Appeal, and the Court of Appeal said there has to be a nexus between the incident and worker safety. If there isn't a reasonable nexus, then the order doesn't stand, and they quashed the order. That's all that case stands for.
So, we've talked probably too much about the difference between an inspection and investigation, but we wanted to put this case in because that's the one we won. And in that case, which I don't think would happen today,
No.
Warrants were issued after the charges to require interviews of employees and former employees, and the warrants were quashed. But I don't think that would happen today. But what will happen today is the Blitz schedule. So first, working at heights. Falls are still the #1 safety issue in Ontario. That's straight from the Ministry of Labour's website, and it's also from the many cases we continue to see. And it happens with small business And it happens with large business, with large construction sites, because all things being equal what they are today, people being asked to do more and more with less and less, perhaps. There is a supervisor, but he or she can't be at all the places on a 5-mile long work site at the same time. So that's really important for construction, and you all knew that already. And this is, we're almost over for the will help you learn how to do it part, and the enforcement campaign is coming up in June. October to November of 2017, there were nearly 600 field visits to about 540 workplaces, over 1,500 orders issued, and 93 of those were stop work orders. And that's important, because if you get a stop work order, your business can't do its business. That's 17% of the orders. That's just too high. I'm not saying that the ministry was doing a bad job. I'm saying you shouldn't be that unsafe. And common reasons for orders were PPE not being used. There's no excuse for that. If you have it, if the people are properly trained and they're not using it, you have to know that and use discipline. Guardrails not compliant. People still going up on platforms with no guardrails and not tying off. Portable ladders not being used. There's a case now about a ladder that wasn't in compliance. How can you have a ladder that's not in compliance? Easy for me to say, but let's face it, mistakes do happen because we're all human. But what you want to do is reduce the number of mistakes. You notice that in May to July of 16, there were many more field visits and about the same number of workplaces, a little more. Many more orders, and less than 10% were stop work orders. So clearly, the bad things are getting worse, although the field visits are getting less frequent. And fall protection was about the number one, and continues to be in Canada. By the way, the U.S. OSHA reports that it's either second or third there. They have other issues.
Okay. So we talked very briefly about the Ellis Dawn case before, and I'm not going to go through the facts. It was a working from heights case where there weren't proper guardrails. The reason we put this in, and it's set out in the bullets, is it shows what a due diligence defense looks like and what companies need to have in place. So you have to have the safety department has to be developed. You have to have the experts in place, and you have to implement proper practices and have proper training and manuals and monitoring. But what I wanted to talk about was I looked at some of the cases last night on Working in Heights, and just some practical tips. Before you have a project or before you're working at heights, you want to review your work plans, identify who's going to be working where, when, and at heights. Then, once you've identified the people, make sure they have the proper training, because you'll recall that under the basic occupational health and safety training requirements, there is a working at heights requirement that you get training from a certified trainer. So make sure that that's in place. Also, identify the equipment that's being used. The swing stage case, Metron and Swartz, that led to criminal negligence prosecutions where 4 workers died a few years ago, and it went all the way up to the Court of Appeal. One of the charges under the Occupational Health and Safety Act that the director got convicted of was not checking to make sure that the machine or the swing stage had a load capacity that was in sync with the actual loads that they were putting on it, or that it was maintained in good equipment. So check your equipment. Make sure you have a competent supervisor in place so you know what's happening, and have random inspections. These are just points that you can come to, whatever the inspection is, by looking at the hazard alerts on the ministry's website and understanding where their concerns come from.
The other blitzes that are important are for the reversing equipment. Signalers, still a big issue. Recent case that says doesn't have to be a person whose title is signaler, because if you're a two-person operation, you don't have to go out and hire a third person, as long as someone knows how to and does perform the functioning of a signaler. But I want to address just one question that came in, because we were talking about, the questioner says, primarily industrial manufacturing industries. And the question is, do these blitzes take place within financial services and office environments? And excellent question, because they certainly can. What the ministry is focusing on now, though, are those top 10 causes of injury, and even worse, God forbid, death. But that doesn't mean that you're safe from inspection because you run an office. And we've had situations where as something as simple as having a cord, as electrical cord, as a trip hazard, has been noticed on a visit, and an order's been issued. So fix what you can that's easy to fix, and go looking for those fixes.
Before we pass off on the construction sites, again, if you look at your requirements when you're preparing for these blitzes, and I strongly recommend that you do look at the ministry's website. So, for example, the reversing equipment on construction sites. Well, the construction regulation requires that you have plans in place that set out how work is going to take place, who's going to be working when, and directions. This isn't rocket science. You have to sit down and just plan it out and have those plans ready, because an inspector who shows up on that blitz is probably going to ask for that plan. And you want to make sure the signage is in the right place. And you want to be in a position to demonstrate it. So as long as you sit down and take the hour, 2 or 5 to plan out, and you know where they're going to be focusing, you can address these concerns on blitzes. And that takes us to, we were talking about earlier that the new and young workers blitz is coming up. And we have the statistics there that show how many workplaces were visited last year and how many stop work orders were issued, what the common problems are. And Cynthia and I wrote an article on this, I think about a year ago when this blitz was happening, but just some common sense tips again. And I think Cynthia was referring to it earlier. Sit down, create an orientation package for your new worker that has the policies and procedures. Assign the new worker to a senior mentor. Introduce the worker to a member of the Joint Health and Safety Committee or the Joint Health and or the Health and Safety representative, and have them attend on inspections and follow through on to make sure that those meetings are happening. If you do that, you are going to be in great shape when an inspector shows up, because you'll be able to show the inspector all of these great things you're doing, and they're going to look at you with a lot of confidence.
The other thing is, particularly with young workers, there is a real premium right now on ensuring that they understand harassment policies and procedures at the workplace, violence and harassment policies. I cannot tell you the number of complaints, because you have a lot of younger and university and high school, sometimes university students who go and work for a summer placement. It can be in manufacturing, can be elsewhere. And a lot of times those are at risk in terms of harassment during the course of their summer work. I have a lot of examples over the last 3 or 4 years where young students have come in and have actually needed to understand what the harassment policies were, because they were being harassed at the workplace as being vulnerable employees. So that's very important, and that's going to, and there are real red flags that they're placing on those right now.
And just to follow up on what David and Lorenzo were saying, there's a few questions that have come in that deal directly with this issue. So the question is, what if you have a third-party company doing training, lift truck, working at heights, etc., and you can't provide details of training as its contents that is in the possession of the third-party trainer? First of all, structure your contract with this third-party trainer so that you get the content. Because if you don't know what the content is going to be, how can you satisfy yourself as an employer that it's appropriate? And there's nothing wrong with hiring, quote, experts in fall protection, because in fact they may and usually do know more than you about how to conduct the job safely. But that is not an acceptable answer to an inspector. We don't have this because our trainer kept it. The second thing is you must have someone in managerial and supervisory position to sit in on all the training sessions, because you have to be satisfied that the training is not just being delivered, let's assume they're professional deliverers of training, but that it's being received. And if the supervisor or manager can't speak to what that training comprised, you're going to be in trouble. One other thing, I was just going to deal with the question about what if there's procedures that need to be variable depending on certain circumstances. Well, that's real life, of course. And sometimes when they're written by an engineer, no disrespect, I'm married to one, they can be so detailed as to mean that nobody ever reads them because they know what to do.
They're too dense.
Exactly. You know, so in the same way you don't have to tell someone to tie their shoes in the morning, you don't need to tell them which lace to use first, all right? So I think what's important is that the procedures be clear. So if it says something like there may be different requirements in different circumstances, give a few examples, and with a big, big warning, if you are not certain, ask your supervisor, ask your lead hand. Make sure that you don't make the wrong choice, or whatever language you think works for you. Because it's fine to write, 400 pages of dense procedures that's going to be carried out in 15 minutes by a worker in an office or in the field or on a construction site. They're not going to carry that binder around with them. I think that's very important.
Okay, and just to address one question that came in about what binders and records should you have ready and keep. We were asked a question about what information should be in the binder, because certain companies will have accident reports, previous policy reviews, and I think that our view of the matter would be that you need to have the up-to-date records in the report. So it doesn't have to include the reviews. It has to include what those reviews drove in terms of changes, whatever the current policy is. Accident reports, I don't think you need to have that in the binder. That's information that you'll have available, and you'll obviously produce if requested. But that's not something that everybody has to have right at hand. PSRs, pre-start safety reviews. So we were talking, and our last slide talks about big box retail, and Cynthia was mentioning racking. Well, if you're using racking, you have to have a pre-start safety review done to make sure that the certified requirements are met. I'm dealing with a case right now where there wasn't a PSR in place. You need to have that so that you can give that to the inspector, because that's going to be one of the things on his or her checklist. They know what they're dealing with. They know the requirements. You need to know what your requirements are and have them. And it'll be a good exercise for you, because if you haven't got it, then you know you need to do something quickly. And as Cynthia always says, you don't know what you don't know. Well, you want to know.
Just following on that, obviously you're not going to include all your procedures for all different situations and the actual training on all different situations. But it can be useful, and I think a refresher to yourself as well, to have a index or a table of contents to the areas in which you're specifically required to have procedures and in which you do have procedures. So that shows the inspector, yes, we have these. Here's an index to them. Which ones do you want to look at? Same with training. An index or a table of contents to what training you do. Not every piece of training you've ever done, but an outline of the areas on which you train and how you demonstrate that the training has taken place.
All right. Well, so there are a number of questions that we're still going to be addressing in further correspondence to you in the newsletter, and we'll get to some of those as well. But thank you very much. very engaged audience. We have a lot of questions here that we and Cynthia and David did a good job at trying to work a lot of the answers through as we went through the presentation. So thank you very much to both of you. I actually love these webinars because I learn something every time I participate. And I think I can speak on behalf of the audience. So thank you for attending. We appreciate your continued patronage. I'm going to remind you, we're kind of on a summer break right now for many of our workplace law webinars. We'll be back on September 25th of 2018, where we're going to deal with a very kind of, again, topical issue of cannabis in the workplace. But by that time as well, and as you know, we've got not only kind of legislative developments or lack of legislative developments right now, but we will be further down the road in terms of a lot of the nuts and bolts of cannabis regulation, particularly from an employment and workplace perspective. So we invite you to join us on September 25th. And on behalf of of all of us at the Aird & Burles LLP Workplace Law Group and our marketing team, thank you. Have a great summer, and we will talk to you in the fall.